Before we get into today's mashup, I need to preface it with a couple of things. First of all, there's this.
Again, from that hearing, the motion and eliminate hearing, she was very clear. Like, both sides said, we have no intention on talking about Turtle Boy or bringing any of the witness harassment stuff in at trial. And she's like, like, if either one of you mentions it, the door's open and it's all coming in. Like, she wanted it in. She was very clear about it. Like, she was really irritated with all of that shit that was going on, like all of that noise. You know, like she took like personal offense to it, to the point where I knew if she had the opportunity to allow it in, she was going to allow it in, which she did.
So there's that. Auntie Bev was bringing it in either way, but at the end of the day, the issue was who brought it in, who opened the door. So before we get into the mashup, we're just going to have a quick look at what it was that Yannetti said that Auntie Bev believes was him opening the door.
I had asked you if, prior to getting rid of your old phone and getting the new one, if law enforcement ever asked you to, go through the phone themselves, and you had said no, right?
Yes, they did not do that.
And they never asked to do an extraction on the old phone, correct?
No.
What about the new phone that you now have, that you got in December? Have the state police ever asked to do, have they ever asked to look through that phone?
No, I don't think so.
You provided the screenshot that was shown to the jury today on August 25th when you talked to the state police in this case, right, of 2023?
Correct.
And when you provided them that screenshot, did they say, hey, by the way, can I look at your phone to see if it's on there?
Objection.
I'll allow that. Did they say that to you?
I don't remember.
But in any case, you never physically showed them your phone, right?
No.
You don't recall clicking on that text message app, the green app with the kind of white speech bubble. You didn't click on that and then click on the Colin Albert conversation and say, here it is, did you?
No.
And in addition to not asking you to see your new phone, they also did not ask you to do an extraction of your new phone, correct?
Correct.
And at some point in time, you realized that you'd have to be a witness in this case and have the unfortunate incident of having to talk to me, right?
Objection.
I'm going to see Counsel Tybart for just a minute on this.
And so it was this line of questioning that Lally thought eliciting this type of a response was appropriate.
What, if any, harassment was there in relation to that and in relation to Colin?
Well,
No, go ahead. She can answer.
Colin wasn't at the house, so he's being harassed he was not at the house when John was there, so I drove him home. So the people are harassing him, saying he was at the house when it's not true.
When you speak about harassment, what specifically type of harassment are we
Constant phone calls, emails, awful messages.
Objection.
I'll allow it. Focus on this witness, not Colin Albert at this point.
As far as you and your family, what, if any, type of harassment have you received?
People showing up at our house, people emailing my school, just like a lot of harassment. Can I have a moment, please?
Sure.
Okay, I'm sorry. I have some, thank you.
And how long a period of time has that persisted for?
Very long time.
Now, my issue with this is going to be completely different to what the lawyers will raise in this mashup. My issue is, from the time that Officer John O'Keefe was found dead on the Albert's front lawn, through to Karen's first arrest, and then beyond that to Karen's second arrest, there was no publicity or harassment happening from the general public. That all happened months later in 2022, I think, or maybe even 2023. I'm sure someone will correct me there. But it did not happen right up till Karen's second arrest. So you can't tell me that Yannetti asking why she didn't hand that text message over to law enforcement until over a year later has anything to do with the harassment. The timeline's all wrong. They were investigating second-degree murder, which was the appropriate time to hand these text messages over. Then the second arrest came, and then months and months later it went public and people started sending them messages and harassing them online. That's the time order. And before we get into the mashup, I just want to be clear. I do not condone the public harassing people online for any reason. That is quite aside to somebody with a journalist background ringing people involved with the trial and asking them questions. These are two completely separate concepts. Anyway, let's see what the lawyers have to say.
I also do think it's kind of interesting because that is the moment when a witness breaks down. Not over John O'Keefe's death, not over the fact that maybe they could have done something, not over anything. It's over, that they have been treated badly. And that's the moment a witness breaks down. They have mentioned, his children being orphaned. They haven't, they didn't shed a tear. They've mentioned, his death. They didn't shed a tear. They mentioned passing by him as he was dying in the snow. They didn't shed a tear. What did they shed a tear for? Themselves. Because this has been hard on them.
I've asked every witness, when was the first time that they spoke to the state police? That was the first time Ali McCabe spoke to the state police. None of that conversation had anything to do with harassment whatsoever. It was strictly related to the death of John O'Keefe and the investigation of John O'Keefe. I stayed completely clear of any discussion of harassment whatsoever. I only focused on the federal grand jury and the approach by the state police on August 25. I opened no door. I didn't even approach the door. And yet that evidence came in. It led to a moment where, that Mr. Lally, I believe, has been waiting for, which is for a witness to break down on the stand and feel sorry for themselves to gain sympathy before this jury. It was prejudicial to our client. It was prejudicial to our defense. It is error, and we're asking the court to correct it. Of any discussion of harassment whatsoever, I only focused on
correct.
The federal grand jury and the approach by the state police on August 25.
He never mentioned anything about it.
I didn't even approach the door, and yet that evidence came in.
I 100% agree with him on this argument right now, because, when it comes to these sort of things that are more prejudicial than probative, the question really becomes, did they do something to open the door to this testimony? Because, the judge can have ruled before, no, this stays out because, it's really not probative. It's more than anything, it's going to be prejudicial. The jury's going to be led astray by hearing this kind of information, and it's not going to actually help them determine the case on the merits. They might get distracted by it and go down this whole side quest of an improper reason to make a determination in the case. And so the question is, what did the defense do to open the door? So she had determined yesterday that the defense opened the door, and this is what he's saying here, I believe, is accurate from what I remember in reviewing the testimony yesterday, that, him asking about these text messages that are being brought in, he has every ability to ask about these text messages of the fact that she didn't provide them to anyone before any point. And he didn't talk about anything that was harassment. He didn't refer to any sort of social media presence or media presence, or any sort of any sort of attention that the family broadly has received as a result of this trial. They didn't talk about any of that.
Completely agree with you, Nettie. They didn't come anywhere near the door. He asked the same question. He asked so many other witnesses. That's exactly what we said on the live stream last night. Literally, he's asked witness after witness that same exact question. Never was that opening the door. Never was that discussing harassment or things like that. Yet the judge just allowed them to dig into it.
And Yannetti did not open the door on anything having to do with harassment. He asked every witness about the other proceedings they testified in. That has to do with the federal grand jury and what they're allowed to bring in and how they're allowed to bring that in.
I mean, that's basically correct, and in basically every single way. Like, he's correct that he wasn't really asking those questions. And so the answers were improper, and that it led to this extremely prejudicial result that occurred in court. And incidentally, of course, the lawyer is doing exactly what he's supposed to do here. He's supposed to try to give the opportunity for the trial court to try to correct the record. You know, you don't make your objections, you lose it. You use it or you lose it when it comes to objections. And so he's doing the exact right thing. He's like, look, I did not open this door. As it relates to this, I simply asked these other questions. I didn't ask the questions relating to harassment. This was completely improper. The prosecution's asking questions, getting this breakdown the stand for pure sympathy play. It's prejudicial. It's improper.
And so it does seem incredibly improper for that to have somehow opened the door, because that means that any number of these witnesses can open the door just by the defense like properly asking, like, well, where the hell does this screenshot come from, and why didn't you introduce it earlier? Like that seems an entirely proper line of questioning, and I don't think that opens the door.
Your Honor, counsel absolutely opened the door as far as the questioning was concerned. It was not just...
Did they now?
The characterization of the questioning is just simply inaccurate. As far as...
Okay, Lally, you're saying he opened the door. What did he say that opened the door? What was it that opened the door?
As far as...
How did he open the door, Lally?
Like questions that were posed to the witness, it was as far as the... questions that were posed to the witness, it was more geared towards why, implying that the witness only provided this after testifying at the other proceeding or being questioned about it in that environment, and that's the only reason that she had these messages, and why hadn't she turned these messages over earlier? And that is in direct response to the harassment that witness and her entire family, as well as Mr. Albert, had sustained as a result of actions.
I don't understand logically how he could have thought that Q&A between Yannetti and Allie McCabe somehow would have led him to just try to drive a truck through this opening about this campaign of alleged abuse.
And the thing is if you look at Lally's question that elicits this wasn't why did you release these texts later? It was very specific about, like, what have you suffered since then? Come on. Your question wasn't addressed to the texts. It was addressed to getting that response.
And why hadn't she turned these messages over earlier? And that is...
Even why wouldn't do the trick, right? So, like, when did you turn them over? Why didn't you turn them over earlier? It's still not going to harassment. It's basically the fundamental question. Even his own description doesn't do the trick, which is hilarious, right? If he's asking questions like, hey, when did you turn this over to the police or the grand jury or whatever, and why didn't you turn it over earlier? Those are like perfectly proper questions, and there might be perfectly good answers. Such answers as, I didn't have it earlier, or I was scared, or whatever, right? But it's a perfectly reasonable question. Why are you just coming up with this? Why are you just presenting this now? That isn't not asking about harassment. It's just asking about the timing of things. So even his own description belies his argument.
By several different parties, including counsel. So for those reasons, it was proper. There was nothing, I don't think it was more than 5 minutes of testimony concerning it, and it was because counsel opened the door to it.
Nope, wrong. He's wrong on the law and the facts.
I completely disagree with Lally. I don't remember it that way. I disagree with the judge letting it in the first place. Let's see if she changes her mind.
So, Ms. Giannetti, I remember clearly the lines of inquiry that you initiated. So I disagree with you in the strongest way possible. You've made your record. Your motion's denied.
Thank you.
Okay, so let's bring in the jurors, please.
I 100% disagree on every level with that ruling.
That's pretty shocking. It's just absolutely bonkers. It's not even close. This is not a close call, in my view.
What a big surprise. Oh, I thought that she was finally going to rule. Was his questioning anywhere near what she claims?
I don't recall it verbatim, but
what, if anything, do you recall?
I disagree with you in the strongest way possible. You've made your record. Your motion's denied.
Thank you.
Okay, so let's...
What kind of conclusory crap is that? What kind of conclusory crap is that? If you really believe that he opened the door yesterday, then why can't you provide some sort of explanation about how exactly he did that? Because maybe my perception is wrong, Your Honor, and you can teach me, just like you can teach perhaps the audience watching, including the public watching. You can provide your argument about why you perceive certain things a particular way. The state has made their argument, or the Commonwealth has made their argument, defense has made their argument, be like, no, this is how I perceive things. I was there, and this is what you said, and this is what you asked, and so forth and so on. But none of those things. It's completely conclusory.
If she gets convicted, if Karen Reed gets convicted, expect an appeal on that issue. That's what I would totally expect an appeal on that issue. I disagree with this decision by the judge entirely.
It's disgraceful because it's not relevant to the issues at the trial. All it can do is prejudice Karen Reed. And the idea is these people are witnesses or whatever they are. This case is not about whether, poor Colin Albert feels like he's been intimidated by witnesses, by people in the case or whatever, or bloggers, whoever. It's just not appropriate. And the judge is supposed to be the gatekeeper of a fair trial. And I think she completely yesterday lost control of it. And now it's a complete shit show on this regard.
It's completely just reductive. It doesn't provide any example. It doesn't provide any explanation. It's just like, nope, I just clearly disagree with your characterization because reasons, which I'm not going to provide, even though I have so many reasons I could pick from. It's hard to pick even one. Could you give me an example? No, there's just so many. I can't pick one. How about an example? No.
So there you have it. Not only did Yanetti's questioning go towards the botched police investigation, but his line of questioning also went to third-party culprit defence. It did not go to harassment in the future. That hadn't happened yet. Thus, I am satisfied that all of these attorneys are actually correct. Let me leave you with a final thought from Kurt at Uncivil Law.
Judgment is not the same thing as bias. Just because they're always ruling one way or just because they're always ruling the other way does not necessarily bias make. Nevertheless, after all this, at this point in the trial, what are we, 14 days into this trial, and with the judge making ruling after ruling after ruling after ruling that defies my understanding of legal principles, it's becoming much, much harder for me not to say, hey, this is biased. And so I'm just going to say it. It's biased.